At Cape Fear meeting. We are super excited to have you all here with us this evening. We have a group of team members here, leadership team. We are all wearing the beautiful colored shirts, so you'll be easy to identify someone if you need assistance. And I'm Ruth Finch, and I get the honor of introducing the founder of ACAP. And Frances Hall is with us. She came from Hickory, from Morganton, actually, to be with us this evening for our inaugural meeting. And Frances is the founder and executive director of ACAP, Adult Children of Aging Parents. From the time she was a child, she always knew that she would be her mother's caregiver, and she wanted to do that. But when her mother needed support and moved to North Carolina, Frances realized that caregiving was harder than anticipated and didn't know where to turn for help. She was working at Lenoir-Rhyne University in Hickory and realized there were other faculty and staff who also were struggling with how to best care for their aging parents. Frances began inviting them to a once-a-month support group just to share insights and concerns. In a few months, she started inviting speakers to come to the meetings, and at that point, ACAP was born. A couple of years later, people began asking for their programs to be offered in the Hickory community, and several years after that, with the assistance of Dr. Jan Everson, a disabilities expert, chapters began being established in other communities and states. Frances grew up in Alabama, did her undergraduate and graduate work in Georgia, and has been in North Carolina since 2000. A true Southern belle. Her background is in higher education and nonprofits, working in student services, institutional advancement, and church-related ministries for 30 plus years before beginning ACAP. Marrying for the first time at the age of 53, she and Bill were married for 11 and a half years before he died from leukemia in 2019, just a couple years after her mother's passing. Frances now is blessed to claim 3 adult stepkids, their spouses, and 3 grandchildren as her wonderful family, and continues to be excited about watching and helping ACAP grow. And the ACAP's mission is to provide information, resources, support, and community with the programming listed available, and these programs are supported. They're nationally recognized as support programs. So Frances, would you like to speak?
Sure.
Briefly?
I don't know that I need a microphone, but just in case, I am delighted. I am thrilled to be here. I am looking at you all and just going, this is phenomenal. I am so grateful to Dorothy and to Ruth and the entire leadership team, most of whom have on the shirts, but not everybody, right? A few don't. At any rate, we are so grateful that you are here. And I just really hope that ACAP will be a program that will be meaningful for you. I want to talk just a few minutes about a couple of things. Yes, about 10 years ago, I was in your shoes. I was caring for my mom. I didn't have a clue where to go for resources or who could help. And as I was running out my office door practically every day, saying I'll be back sometime, mom has an emergency, I started realizing this is big. This is a lot bigger, and I'm seeing some nods of heads. It's a lot bigger than one would ever think at the beginning. So as I say, I created ACAP for me, and it just so happens that other people have benefited and continue to benefit from ACAP, but selfishly, I created ACAP for me. What is ACAP? Adult Children of Aging Parents, and the mission is to provide information, resources, support, and community. So it's all of that. As adult children are caring for their parents, but also as they care for themselves. Anybody who is in this caregiving realm knows that yes, you want to care for your loved one, but you also have to take care of yourself. And so part of what we do in ACAP is to provide the resources and the information to help your loved one, but also to make sure that you get the care. So it's this group and it's the community and it's support for you as you are on this journey. ACAP's core is education. So yes, we're a support group, but primarily we are an educational program. So all of the programs, your speakers will be local content experts. Your sponsors will provide resources for you, but all the programs are going to be evidence informed. So it's not like a sales pitch for anybody. It is true information that you're going to be getting. ACAP is not disease specific or condition related. What we have done is we have identified by research what all of those topics are that are common to caregivers. And so the curriculum, all of our programs are based on an ACAP curriculum, and the curriculum is based on the research of all of the issues that most caregivers face in caring for an aging parent or an aging loved one. I hope that you will find the programs meaningful. This leadership team is phenomenal, and they have worked really hard already to start this program, to start this chapter. And every month they will be offering programs. So please come back, bring a friend. It's definitely the best is to come in person, because that way you get to look around the room and know you're not the only one in this boat. But there are times that schedules just don't allow that. So I want you to know that on our website, you can also view the programs or join the programs virtually. You can also look at previous programs, videos. We have podcasts, we have blogs, we have all kinds of resources on the website. So go to our website, www.acapcommunity.org. The other thing I want you to know about is that November 4th, we have our third annual symposium, Caregiver Symposium, November 4th, which is a Friday from 1 to 4. This year, Amy Goyer, who is the AARP's national caregiving expert, is going to be our keynote speaker, and Donna Thompson and Dr. Zachary White are our other speakers. Donna and Zachary wrote a book, and I love the title of it, The Unexpected Journey of Caring, the Transformation from Loved One to Caregiver. Anybody in that boat? Like everybody. Registration will open October 3rd, and you will be hearing more about that, but I want you to get that on your calendar. It is a virtual program, and it's national. Last year, we had more than 900 people register for the symposium. So we are expecting, hopefully, at least that number again this year. If you have any questions, please make sure that you talk with your leadership team. Let us know if you have any questions or what your needs are. Thank you so much for being here, and thank you for your support of ACAP. And thank you, Ruth and Dorothy and the entire leadership team. Thank you.
And we really appreciate you making the drive. It is no small feat, but coming across. Just a few housekeeping things of sorts. If you need the restroom and you're not familiar with this location, there's a reception desk just outside the door when you turn right, and you'll go around the corner, the curve of that to the left, and there's a men and ladies restroom down that way. There will be some leadership team available to assist you to find the restroom if you have the need. And then on your tables, you will find ACAP pins. You will find the first 6 months of programming for ACAP Cape Fear that you want to be sure you take with you, unless you look it up online. It will be there. And there's also, we have forms. If you have not signed up online and you have not already completed one tonight, there are small index cards that you can sign up for our emailings, where we will alert you to the upcoming events or summarize the events that we had as they occur. Our sponsor, each program has a sponsor, and our sponsor for this evening's program is Lower Cape Fear Life Care with Jason Clammy. If Jason wants to come up, say a few words.
Just make this very quick. Thank you for being here tonight. It is a journey, as a few people have talked about the whole caregiving thing. And we as Lower Cape Fear Life Care know that and realize that we feel like sometimes the care that we give to our patients is actually exceeded by the care that we give to our caregivers and their families. And we acknowledge that, and we want you all to know that we are here during that journey as well. I've got some information in the back about some of our services, but also related to the conversation and the planning and the things that you're here for tonight. Willing to help and do whatever we can to help facilitate that as well. So thank you again for being here. It's our honor to support this program. Thank you.
Thank you. They do an exceptional job, outstanding job. And then I do want to say thank you on behalf of Dorothy and myself to the leadership team. They are amazing. Francis has tagged it. There's a lot of work and a lot of intelligent people in this room that tonight could not have happened without their talent and their skill that they brought to the table. So thank you to each member of the leadership team for all that you did to make this happen. It's exciting. So our program this evening, what we're all here for, is Miss Jennifer Marshall Roden, is an associate with Craig & Fox here in Wilmington. She's certified as an elder law attorney by the National Elder Law Foundation and is a North Carolina board certified elder law attorney. Her principal areas of practice are elder law and estate planning. She assists the New Hanover County Public Guardian, Lawrence Craig, in his capacity as guardian of the estate for wards in New Hanover County. She also manages guardianship cases for private clients in New Hanover and surrounding counties. She is secretary and membership chair of the Elder and Special Needs Law section of the North Carolina Bar Association, as well as a council member of the North Carolina chapter of the National Academy of Elder Law Attorneys. She is past president of the New Hanover County Estate Planning Council. She is a 2012-2013 Orchard Foundation Center on Law and Aging Fellow. She's also an Elder House board member, I must say. And she's a super busy woman, and we're so grateful that she's with us tonight. She did receive her BA in political science from the University of Alabama in 2009, and her JD from the University of Alabama of Law in 2012. So Craig & Fox, it has information available. Jennifer is happy to share the information at any time about their services with you, but we are super glad to have her come and share her expertise with us this evening. Jennifer?
I've never used a clicker before, so this could be really bad. Nikki worked so hard to get the PowerPoint up there, and I'm just going to mess it up now that we start. So just briefly, I can relate to a lot of people who are caregivers in the room, not because I've had the opportunity to do it yet for my parents, but I have watched my grandmother care for my great-grandmother, and I am watching my mother care for my grandmother. They are all still in Alabama. But I knew from a very young age that I would be working with seniors in some capacity. And I learned very quickly that nursing was not going to be that for me because I get very squeamish around anything that has to do with bodily functions. So those who can do caregiving, I envy you. And, you know, I know it's one thing if you give caregiving in a formal setting, but to be a caregiver for your own parent, I have heard many stories from my grandmother about, you know, what a transition it is to have to bathe your own mom or change a diaper or help her change her clothes. And it's just a very different role. So I knew I was going to do something with seniors. I went to law school, and after the first semester, like I think many law students, I was ready to quit. But we had a professor come in and talk about elder law, which is something that most people know nothing about. And elder law, the big picture is we work mainly with seniors or their caregivers. And an elder law attorney practices what I would say is a general practice firm, because it's not really about the specific area of law, it's about your client. And so we do a lot of things. And so it could be estate planning, it could be long-term care planning, it could be evicting a child out of the house because they're not paying their rent. It could be suing someone because they have overstepped and breached their fiduciary duty under a power of attorney or a trust. So it's a fun area to practice in, but it allows people to be a little bit more empathetic. I will just say for estate planning purposes, which is a huge part of my practice, today alone, my very first appointment with clients in their 80s, my very last appointment, my clients were 32. So estate planning is for every age. It is not just for seniors. It is for young adults, gotta be at least 18, but everyone needs estate planning. So this is the only funny part of my entire presentation. Estate planning is not funny, and if you're from the South, you may not know what this is. This is a snowman, and it's made of snow, and it melts in the sun. And so if you can't read it, it says, "Mr. Frosty, it's March. We need to start talking about estate planning," right? So that's the only funny thing I could find. Let's see what happens. Okay. So far, so good. So we have a long list of people here. Does anyone know what any of these individuals have in common? Aretha Franklin, Prince. Anybody? They are all dead. But what else do they have in common? Every one of these individuals passed away without a will. Yes. So really, really influential, very rich folks, right, never did estate planning. So it's not just us, right? Everybody fails to do something like this. What about these folks? What do you think they have in common?
They did.
No? Harper Lee, you're from Alabama, right? We love Harper Lee. All of these folks did not have powers of attorney in place, and they were exploited by their caregivers. Okay? So again, very influential people can still be taken advantage of. So imagine, right, what individuals who don't have managers, who don't, they're not in the limelight, the spotlight every day, right, what they might go through. So estate planning, excuses. Why don't people plan, right? I mean, some of the younger clients, well, I'm going to live forever. I don't need to worry about it right now, right? Maybe they're like, well, I'm never going to need estate planning. I'm really healthy. I'm not going to be disabled. There's nothing to plan for. They're never going to need long-term care. They don't need someone else to make decisions for them. That's the most popular one I hear is I'm in charge. I don't need anyone else in charge. Or they just don't want to talk about it. So a very common thing I hear from folks is they don't want to do this kind of planning because they feel like for some reason the universe at that point will say, okay, well, you're all set, time to go. And I mean, really, they think, oh, I have a will, that means I'm going to die. And that's not what happens. I've never actually had that happen, if that helps any. And I've been doing this for 9 years. So reasons to plan. Most importantly, you actually maintain control. So maintaining autonomy to make decisions for yourself. And I know that seems counterintuitive if you are signing a document to put somebody else in charge. But there will be a theme through this whole thing because we do tons of guardianship in my office. If you don't have documents in place and you don't choose who will be in charge, the court will do that for you, okay? And guardianship is not something anyone should have to go through. It is a necessity in a lot of cases, but we want to avoid it. It takes pressure and burden off of your family, right? Various estate planning documents allow you to pick that one person you trust to handle things. It might put you in a position where you say, I want this daughter to be in charge, and I'm sorry, son, I just don't trust you to do it, right? Or you're too busy and you can't do it. But it's important to help your family make those decisions for you so that they're not faced with this burden of having to go to court or figure it out together or pull together all of the siblings that don't really get along, right? You can avoid the court intervention. Again, theme. No one wants to go to court, including the lawyers, I promise. You can save money. Guardianship and going to court about anything is extremely expensive. So expensive. And someone has to pay for it. And they don't have access to your money to become your guardian. They have to pay for it out of pocket, right? And that is a huge financial burden on children or siblings or other caregivers. You can provide for those you love. So with various estate planning documents, especially if you have disabled adult children or disabled grandchildren, or if you have a spouse, right, you have the opportunity to set things in motion that if you can't sign that check, if you can't make that decision to support someone, you can put documents in place to allow that to happen for you. It also allows you to support your favorite charities or organizations, right? A lot of charitable organizations really need support. They need financial support, and this gives you the opportunity to make sure that you provide to that. A lot of people have charitable inclinations, but they don't have the ability to give during their lifetime, right? But at your passing, that might be your opportunity at that point. And again, you can avoid exploitation or abuse. So for those individuals on the second slide, like Harper Lee or Buzz Aldrin, right, if they had set up proper documents, or if they maybe have been advised by somebody to tell them why it might be a bad idea to name this person as your financial agent, they might have avoided some of the things that they went through. So what is estate planning? Estate planning is not just a will. Estate planning could be powers of attorney for finances, could be healthcare powers of attorney, could be a living will. Call it advance directive, which is a horrible thing to have to say over and over again. Advance directive for a natural death. A living will is what we normally call it. Revocable trust, irrevocable trust, asset protection trust, special needs trust. That is all estate planning. Naming beneficiaries on bank accounts is estate planning, right? But when you put the whole picture together, that's when you know you've got something that fits well and it doesn't contradict over certain documents. I'm going to go over many of these documents, but not all of them. And this is the part where I say, I don't want to just talk at you. And we're going to go over document by document. You should just ask your questions for each document, okay? And I'm fine. Shoot your hand up and I'll repeat the questions so that they have it on the recording. But I would rather this be interactive. The only thing I will say, lawyer speech, I am not your attorney. I cannot give you legal advice during this presentation. So if you have a specific question, don't ask it in front of the whole group. Just pull me to the side later and I'll talk to you. Okay? All right. So durable power of attorney. This is often referred to as a financial power of attorney or a general power of attorney. Lawyers like to use different names for things, but they're all the same thing at this point. So a durable power of attorney allows you to name someone to manage your financial and legal affairs if you cannot manage them for yourself. Okay? There are different types of powers of attorney. What I mean by that is there's one that can go into effect immediately, and there are springing powers of attorney, which are powers of attorney where there's actually language that says this cannot go into effect until I'm incapacitated. I don't like those because getting any doctor or any other person to put in writing that you lack the ability to manage your financial affairs is going to be really hard. I like the ones that are effective immediately because, quite frankly, if you can't trust the people you're naming not to overstep, you just shouldn't name them, right? So you get to choose who the person would be that you want to manage your financial affairs. Question. All right.
If you've only got one child, and that's an adult child, don't they automatically get to take care of us, or?
Right. Okay. So the question is, if you only have one child, an adult child, don't they automatically get to take care of you? The answer is no. So there is no law, including our guardianship statutes, that say first dibs is the child, right? If there is not a legal document that gives them that authority, they do not have the authority to manage your financial affairs. They can't file your tax returns. They can't check, they're not even supposed to check your mail. They can't access your bank accounts or your retirement accounts. They can't sell your real estate. So if you don't have that power of attorney in place and it's too late for you to sign one, we'll talk about that in a second too, their only recourse, because they're going to run into an issue one day, is they're going to have to do guardianship. And at that point, the clerk of court determines what's in your best interest. And so that may not be your child. It could be the New Hanover County Public Guardian, right? And we have 110 of those right now. So this, again, you choose, right? You have the autonomy to say, I want it to be my child. And if you don't want it to be your child, there's another opportunity, right? Say, I don't want it to be my child. And that's very common. I have lots of parents come through that I don't trust my kids to handle that right now. So you have the opportunity to pick who that would be. You can do alternates, which I think is a really great idea if you have enough people you trust to layer that document. So if you name a spouse first and they're incapacitated or passed away, you've got someone else who can serve. The biggest question I usually get is, can you name co-agents? So a lot of times parents have multiple children, right? And they don't want to hurt anybody's feelings. And so they want to name everybody together because they work really well together. They don't. I don't care. I mean, I can count maybe on two hands my entire practice where that actually worked. And usually when we get involved, the cynic in me, it's because everybody's fighting. Right? You have two named agents. They have equal power to make decisions and they don't agree on what needs to be done. And now you've just put them in a position that the only way to resolve that issue is a guardianship, right? Because if they can't figure it out and they have equal power, somebody's got to win. So they're going to go to court. Our local clerk of court often will take the position if the whole family is fighting, she just takes it out of their hands. She says, all right, I'm just going to put a neutral guardian and you guys just have a relationship with your parent at this point. So again, if you can pick one over the other, right, that is a better plan. You can promote some family discussion. If you're close to your kids and you don't want anyone's feelings to be hurt, talk to them. It's not uncommon for families to get together and say, all right, these are the documents we're putting together. Joe, we want you to manage money. Katie, you're going to manage healthcare. And figure out how they feel about that. If they don't all get along, you may not want to open that can of worms for yourself now, but if you feel comfortable, just do it. Just go ahead and get it out in the open and let them know who you're naming so they're not fighting later and saying, you made mom sign this document. You know, there's no way she would have ever appointed you. The more comprehensive the power of attorney is, the better. So North Carolina adopted the Uniform Power of Attorney Act in 2018, which was really great for the most part. But I think people got a little complacent with it, and we have these statutory forms where you can initial all these powers, and it's a 2-page document, and that can do in a pinch. But if you can be more comprehensive with the document, the better. For example, gifting is a specific power that you have to give your financial agent to make gifts on your behalf. So if your document is silent on gifting and you have a disabled adult child that you are still taking care of, you haven't given your agent the ability to continue to support that child, right? So you want a document that's specific to your situation. If you haven't done Medicaid planning and you are interested in the idea of asset protection, but you're not ready to do that yet, maybe you're in your 50s and you just don't feel like it's quite time. Having a power of attorney that specifically gives your agent the ability to do that is important. You can do a financial power of attorney on the internet, or you can go through LegalZoom. It is available, but the benefit that an elder law attorney can provide to you when you do that document is they're going to ask you tougher questions than you're going to get asked when you're filling out a form online, right? Anybody that comes to my office, and I know any other elder law attorney in our area that I work with, and we do a lot of cross referrals, we're going to ask some really tough questions about personalities and financial issues for your own kids. And do you have children who are disabled or grandchildren? Are your kids in a good marriage, or is there potential for divorce? And we're going to talk about a lot of uncomfortable things because we are thinking about how do we make this document comprehensive enough that you're going to be protected in the future, right? I can't tell you the number of times that I've had someone come in, they want to name their daughter to manage their money, but they really don't like their son-in-law, right? They say he just blows through the money. I'm worried about what he's going to do. Well, how much influence does he have over your daughter, right? Is she going to be influenced to use your money for her own bills because he used their money for something else, right? And it's not a fun conversation to have, but you have to have it to protect yourself. And you really want to have a financial power of attorney in place to avoid delay in paying your bills or taking care of things. So if you get in a car accident and you're in the hospital and your power bill is due and you still write a check every month, you don't do auto pay, right? A lot of seniors don't like auto pay. If you don't have a power of attorney, they're not going to be able to pay that bill for you, right? The guardianship process, at a minimum, it will be a month before someone is appointed, and that's good in New Hanover County. In other counties, it is 6 months before you can get in front of the clerk sometimes. So powers of attorney can be used a lot more quickly so that they can take care of your affairs when you can't take care of them for yourself. Have any questions about the financial power of attorney? Amy's just smiling because she's like, yep. She sees this every day. No? Okay, we're going to move on then. Healthcare power of attorney. So it's exactly what it sounds like. It gives you the ability to name someone to make medical decisions for you. And this is the one I think caregivers are most concerned about having, right? If you need to take the person you're caring for to a doctor's appointment, you really need this in place, right? So that they can talk to you openly. If the person you're caring for has dementia and they're like this, and they have really lucid moments and they seem very clear for this random appointment at MedAC and they've never seen them before, and they say, I don't want my daughter in this room. They're not going to let you in the room, right? Healthcare power of attorney would be very helpful, right? Again, you maintain control by choosing the person or persons you want to make medical decisions for you. And that I think that gets fought over a lot more, sometimes in the money, especially when you have a very frugal child. I'll say frugal because I think that's the kind way to put it. They don't want to spend any money on your care because that's their future inheritance, right? For your healthcare power of attorney, they're going to ultimately make the decision about what care you're going to receive. If they say mom is going to go into the most expensive facility in town, and I don't care if that means she has nothing left at the end of the day, they make that call. So it's possible to name different people, right? Maybe you have a child, you like that they're frugal. You like that they're not just going to blow the money on things and they're going to investigate everything. But you don't want them making healthcare decisions for you, right? You want somebody else. I often tell folks when they have 2 children or multiple children is maybe divvy up the job, right? If you really do trust everybody, put one in charge of money, one in charge of healthcare, make them backups for each other and force them to figure it out together. But at least you have a tiebreaker, right? You've got the person who's going to make decisions about money and the person making decisions about healthcare. Again, you're avoiding guardianship. So I don't know how many of you have dealt with the Department of Social Services here. We have some wonderful social workers there. They work their tails off. They are the public guardian for New Hanover County. And for most counties, the local Department of Social Services is the public guardian if the court needs to appoint someone to make medical decisions. So that scenario I talked about where the kids are fighting and no one can agree on what to do and the court just says, I'm going to take it out of all of your hands. That means it's going to be placed in the hands of the Department of Social Services. And again, we have some great social workers, but they don't know you. They don't know your parent or your loved one, and they're going to have to start making some tough calls at times, right? I mean, I've had cases where there's a loving family right there, and it is an end-of-life decision that needs to be made about whether or not to take a parent off life support, and it's not the family's choice. Now, I haven't had it be that bad, but still, it's very emotional time, and you don't want some random stranger in the room making the decisions. You want to make it as a family, right? Again, you can help your family avoid that and the fighting if you pick the person you want to make those decisions. I will always advise against co-agents for a healthcare power of attorney. I don't like co-agents and healthcare power of attorney because in the middle of an emergency, if the doctor's standing in the room and your agents are in there and they both have equal power and they want something different, and that doctor's calling the lawyers, right? They don't want to make the call on who gets to decide. That just means that your care is delayed, right? If they need to make a decision about something and they can't agree, then you're the one suffering, no one else. So again, choosing someone to do that. Another question I get asked often is, does geography matter about who you name in these documents? If COVID has taught us anything, it means they've taught us that telehealth is possible. And I have found that healthcare agents that live out of state have had an easier time making decisions for loved ones when they end up in the hospital or in a doctor's office because they can get on FaceTime, do some sort of telehealth decision. Before COVID, I would have strongly suggested you have someone local at all times. It's not absolutely necessary, but if you have someone local you trust who could show up at the hospital at the same time the ambulance pulls up, it might be a good idea to name them. But really, it's okay. If all of your kids live out of state, I have lots of retirees who come here, they have no family here, but you really trust your kids, it's okay to name those kids as the healthcare agent. And we do want to avoid delay in medical care, right? Medical care is extremely important. Delays could mean the difference between life and death. We don't want a delay. We don't want to have to go to court to make decisions. We need somebody to do that for you. Any questions about the healthcare power of attorney? Yeah.
Great. What if, say my mother is mentally right now challenged, and I know that you probably have to speak with her privately to make those decisions. Is it too late for her to be able to put that in place if she has some dementia or confusion?
Not necessarily, right? So if a lawyer is drafting the documents, the lawyer has the ethical obligation to determine if their client, which would be your mom or any other situation, has the capacity to sign legal documents. A diagnosis of dementia alone is not enough to say that someone lacks capacity to sign these documents. I have many clients who have been diagnosed with dementia and they sign things. I have clients who are on the autism spectrum and they sign things, right? It's every single estate planning document has a different level of capacity that's required. So testamentary capacity for a will is actually fairly low. The capacity to sign a financial power of attorney is actually really high because you have to think of like the ability to contract with someone. Healthcare power of attorney, not as high. But again, it's about the person understanding what the document does. So what should happen if your mom were to meet with someone is they should meet alone with the lawyer. It's okay if you try and help coordinate the appointment with the attorney, but if you call a lawyer's office on behalf of someone else to set an appointment, what you should hear back from that lawyer's office is, thanks so much for the call. Please have that person call us. And it drives people crazy, but we have to establish at the very beginning who that client is. Because what we don't want to happen is whatever we've drafted be challenged in the future. And one of the reasons it's challenged is because we let the daughter be a part of every single meeting and conversation. I have had situations where the family brought mom in, she sat down in the conference room with me alone. And as soon as she got the opportunity to talk without someone in the room, she said, I don't want those people in charge of my money. I don't trust them. Here's what's going on. So kids aren't great all the time, right? And that's why we need to meet alone with them. And so every estate planning attorney should meet with the person alone, talk to them about what the documents mean, and we do our own assessment about their capacity to sign something. I'll also tell you that we recognize, especially elder law attorneys, we recognize that certain times of the day are better for people who've been diagnosed with dementia, and we also recognize that their surroundings mean something. So I've had situations where I did a home visit for everything because they were comfortable there. But the moment they came to my office, they were extremely uncomfortable. The nerves got to them and they could not carry on a real conversation with me. But in their surroundings, they were perfectly capable of signing something. So when you talk to attorneys, if you're trying to set something up for your loved one or for yourself and you're having trouble with confusion, talk to them about being able to do appointments first thing in the morning or maybe right after breakfast, right? The sundowners thing, don't do something right after lunch or in the afternoon. Talk to them about maybe meeting with them in person. We also can do virtual meetings. It's not ideal for someone who works with seniors because technology is not always great, but also I don't know who's in the room with them, right? So if you call and say, well, my mom can't get there, but I can set her up on Zoom, great. You know, when it's time to sign stuff, I'm going to make her come to my office because I want to make sure there's not somebody on the side of the camera telling them what to say or do. Did you have a question?
Not really a question, but will you also talk, it's tangential, but will you talk about the most form?
Yeah. And actually I have a slide on that here in a minute too, but
sorry.
No, it's okay. The most forms, it's medical order for scope of treatment. And as a form you cannot do with a lawyer. You actually have to do it with your healthcare provider, doctor, nurse practitioner. It gives you the opportunity to have more in-depth conversations with the doctor about your quality of care and the different treatment options you might want. I like to say it's the opportunity to talk about quality versus quantity of life and map out goals, right? If you're going through cancer treatments and you know your ultimate goal is you just want to make sure you make it to the grandkids' high school graduation, right? Or if you know there are these different treatment options, I only want to go through this one, and if it doesn't work, I'm done. That most order can help you map that out with your doctor. And again, that's such a loving thing to do for your families. So if you have a healthcare power of attorney and that agent is having to make some really tough decisions at the end, if you have that most order, they have something to refer to that tells them what you wanted in the first place.
And it is a physician signed order that nobody can overturn but you.
Yeah. There's a picture of it in the slides here in a minute. I'll show that to you. Yeah.
When is that most order put in place? Is that like all of a sudden, is that situational? Or is that a general?
It's something that you have, for the most part, you have to bring it up with your doctor.
Gotcha.
Doctors often don't want to talk about the fact that you may not make it, right? That's not their job, is to help you get better.
Right.
And so there are some doctors who are better about bringing those topics up and those forms up than others. So you might be put in a position that you're like, hey, I really want to talk to you about this. What I tell clients is it's okay when you set an appointment for your checkup, especially if you're on Medicare, make sure you tell them when you set your appointment that you want the doctor to set aside time to talk about these types of forms. Medicare will pay for that. They'll pay for the time to sit down and talk about those things, but don't spring it on your doctor in the middle of the appointment, right? Because they're not going to have time for it at that point. Or they may try it, but they're just not going to have the time to really dive into it.
I have a question. I have a healthcare power of attorney, and it's sitting in my desk in my house. Got it through Lower Cape Fear Life Care.
Yep.
How, if I'm leaving here and I get in a car accident, who's gonna know it's in my desk at home? Where should that be kept?
All right, so the question is, we have a healthcare power of attorney. It's in an office desk drawer, something like that. And well, if I'm going traveling or doing something, where do I need to keep it? Where does it need to be? Is that
Yeah, like
Yeah.
how would somebody know
Know
if
it
I ended
exists?
up in the ER?
Yeah.
How would somebody know where it is and that my son can make those decisions for me? How are they gonna know that?
So the advice that I give clients after they sign a healthcare power of attorney, there are a couple things you can do. We do have a state system through the Secretary of State where you can store these types of documents, and they'll send you a card with a PIN number. But some people will utilize that system and they'll put the card in their wallet. I don't think it's the greatest system because people lose the card, so they can't remember they ever did it, or they change the document, but they never actually send in the updated document. The other thing I tell folks is because it is the attending physician who determines whether or not you have capacity to make a decision, it's perfectly acceptable to give the healthcare power of attorney to your named agents and to any physician that you see. So in our area, if you are connected at all with your doctor's office, with the Wilmington Health System or physicians group, they're all kind of connected to the hospital. If they have it in their portal, the hospital can access it. And so if you have it in enough places, right, the hope is that if you end up at the hospital, they'll know who to get in touch with. That doesn't solve your problem if you're traveling out of state. I do have clients who keep a copy in their glove box. I don't know if anybody's ever going to look in the glove box to see if it's there, but they take it with them anyways, especially if it's a couple, just in case something happens to one of them, they've got it.
So
Yeah.
just to give a scenario and then we'll move on. So I'm here and my children get notified and they know where it is.
Mhm.
Is that enough to them to say that I am the power of attorney? I can document it at a later time. It exists.
So the question is, if the kids get the call, they are the healthcare agent, but no one else has the document, but the kids say, we know where it's located, we can get it to you later. That is going to be a judgment call for the healthcare providers. I would say that they are doing a risk assessment every single second, right? Do we listen to these kids and hope they're not lying to us? Or do we force them to get that document to us? And I think it's going to depend on the healthcare provider.
Do those, each of those copies need to be notarized, or is just a photocopy acceptable?
A copy of a healthcare power of attorney is as good as the original in North Carolina. So you don't need to carry your original around. Now, there are some facilities when they're doing admissions into facilities, they want to see the original healthcare power of attorney. I don't know if it's worth fighting that. I've tried. If it's readily available, provide it. But our statutes say a copy is just as good.
I have a question, and this was a situation that happened with my mother, and it has haunted me ever since. I had healthcare power of attorney for my mother. My mother had to go to the hospital, and without going into great detail, the doctor prescribed a medicine for her that she did not need to take, and I ended up firing the doctor over it, which was an ordeal too. But as long as I was at the hospital and I refused it, they would not give it to her. But I found out the next day they gave it to her when I left, like at midnight or 2 a.m. So I went to the nurse's station and they said, well, I said, I want to see my mother's file. And they had to show it to me, and they did. And they had written in there, give medicine as soon as daughter leaves. And so they did it. But that haunts me to know that, and so I want to know how much power does it have, because the doctors, they know how to manipulate this stuff. And that's a negative side. That was just a bad doctor. I've had wonderful doctors, but for a while we did not have a good doctor, and it happened.
So for the recording purposes, I'll just pare that down. There was a healthcare power of attorney in place, and the healthcare agent directed that a medication should not be provided to the principal. And they had in the medical charts as soon as she left to give the medication anyways. That is a lawsuit waiting to happen. If doctors have determined that the principal under the healthcare power of attorney does not have capacity to make their own medical decisions, the healthcare agent makes those decisions. You step right into the shoes of that individual. Now, there's some gray area about whether you can load them up in the car and lock them in at a nursing facility behind the door and against their will and things like that. I mean, that gets a little gray, but medications, they should have followed your direction on that. I can't believe they put it in the medical chart, because that baffles me. Normally it's just a secret, right? There's no smoking gun in those cases. Any other questions about healthcare power of attorney?
1,000.
Yeah, 1,000 was the answer. So, I mean, the important thing when you're serving as a caregiver, you're serving as an agent under a healthcare power of attorney, you are an advocate, and no one's perfect, right? There are good doctors and bad doctors, good lawyers and bad lawyers, right? Great healthcare providers and really terrible ones. So if you're serving in that role, it is not an easy job. You have a target on your back as well. I always tell folks that if you serve as a fiduciary under anything, there's a target on your back at all times, because no matter how you do it, someone else is going to say they would have done it better or differently. And so all you can do is advocate. And so in that situation, which is terrible, right? If you had called me in the moment, my gut instinct would have been get her out of there and get those medical records, and then call my buddy who has this law firm that does lawsuits, right? The other thing is utilizing other resources in town. If this had happened in a nursing facility, calling our local ombudsman, right, to get in there and fight for residents' rights, right, and put the facility on notice that they are not acting appropriately and honoring what the document says. Okay, how am I doing on time? Because I can't watch the clock or I will just freak out.
7 o'clock.
Right, let's keep going. Living will. So the living will, big title, advanced directive regarding a natural death. And this is something that Lower Cape Fear Hospice can give you all kinds of information on. Do you guys still have begintheconversation.org? Yeah, so I tell every client about that. A living will is the opportunity to make end-of-life decisions, right? North Carolina, we have 3 scenarios that are covered. If you have a terminal illness and you're going to pass away soon from that illness, if you are unconscious and to a high degree of medical certainty, you're not going to regain consciousness, in the advanced dementia state or some other cognitive impairment, maybe a traumatic brain injury or brain aneurysm, you've had damage to the brain, it's not going to get better. And under those scenarios, if your attending physician and a second physician have confirmed in writing, you have the ability, while you have capacity, to make some decisions about that. So you could choose to just let your healthcare agent figure it out, which is very common among my younger clients because they're not quite keen on saying, just let me go. For older clients, they often will choose this option of, I don't want life prolonging measures, withdraw them. You also have the ability in North Carolina to direct that they keep you on life prolonging measures for as long as possible. And for some religions, that's very important. And when you have wishes about end-of-life care above anything else, those should absolutely be honored. To me, to not have that document in place and be able to do what you would want done for yourself is just horrible, right? And that is why every time you go to the doctor or have a procedure done, they're constantly asking if you have one of these, right? Because I think universally we all agree that we don't want to make decisions. We don't want courts making decisions or disinterested public agencies making decisions about whether or not you get life prolonging measures, right? You should be able to make that decision for yourself. Now, most people don't, some people know what life prolonging measures are, but in the simplest terms, right? Machines breathing for you, tubes and IVs giving you nutrition, hydration, because you can't eat anymore. This is not a situation where you're perfectly capable of communicating your decisions and your wants, and they're just like, yeah, we're not going to give you a cup of water. That's not how this works, right? You no longer have the ability to advocate for what you want, so now we're going to look at this document so it can tell us what you want. If you choose to let your agent figure it out for you, you better have conversations with your agent about what you want. That is a huge amount of guilt to put on someone if they have never talked to you about what you want in end of life, right? So having a conversation to say, you know where I stand on this. If doctors say I'm not going to make it, I'm okay with you letting me go. If you feel really strongly and you're going to put in your document that they have to withhold treatment, you should tell your family that too, right? You don't want them to be surprised, because if you've done your job of giving that document to your doctors and all of a sudden your kids are surprised that you have a living will that says you don't want life prolonging measures, that will be basically a punch right to their gut. That they're going to want to know what you want. The whole point of healthcare planning through powers of attorney or living will is sharing with your agent and your loved ones what you would want in particular situations. Because your agent's supposed to do what you would have wanted, not what they want, right? It's not for me to all of a sudden decide, okay, now that I'm in charge of my mom, this is what she's really going to get, right? I'm supposed to do what she would have done for herself. And even if that's not the same thing I would do for me.
So if you had the living will and your physician has it, but you've reached a point that, you're incapacitated and your son, has the medical power of attorney, living will trumps, or can that person override?
It's up to you. So you can put in the living will that supersedes all things. And if you do that, your agent can't override that. Now, I won't lie to you, when people start threatening lawsuits and things like that, doctors get concerned and scared, and our hospitals have ethics committees and all of these things, right, to combat that. But if you've decided for yourself, I don't want life prolonging measures, ultimately that is the decision that's supposed to be followed. But you do have the ability to say, I really don't want life prolonging measures, but at the end of the day, let my son decide for me, right? So I will say it is 50-50 with my clients, whether or not they let their agent figure it out or they just say, let me go. I've only had one set of clients say, give me maximum treatment, and they were in their late 20s. And I think it was just an idea. They were very young and they weren't ready to let go of that. They didn't have experience with a lot of that. And I think that shapes very much what people want. If you're a caregiver for someone else and you watch that process, you're probably more likely to get that living will done than anybody else, right? Because you know what it was like to go through that with the person you were caring for, and you don't want to put that on somebody else. I think that the living will, people know more about that than any other document when they come to my office, and they very quickly say, oh, I need a living will. So again, it takes that burden off the family. If you have a family that does not get along, right, and you've named one child to make all those decisions for you, but you have 3 other kids who are going to just question everything they do, probably not a good idea to say, oh, and by the way, you also get to decide if I get life prolonging measures, because they're going to be terrified, right? If they are trying to decide to let you go and they have 3 siblings saying that's the worst decision you could make, I'm going to sue you, I'm going to call the cops, I'm calling APS, it puts a whole lot of burden on them. So if you feel confident enough about what you want, just make the decision so they don't have to. But I do have clients who have loved ones who work in the healthcare field, and they're like, well, they understand this language better than I would, and that's okay too. I also think it's important to have conversations with your family before you sign this, and if you can, with your doctor. This is a legal form about healthcare, right? I can't define a lot of things. I'm not a doctor. I may have a JD, and I always tease my brother, who's a pharmacist, that I got my doctorate before him, but I'm not a doctor. And so when someone says, well, what does life prolonging measures really mean? I can only go so far. But a healthcare provider, a doctor, can explain that a lot more. And so I've had clients who have set the time with their doctors, and they actually go through this form before signing it, so that when they come to me to sign it, they feel very confident about what they're putting on paper.
Which doctor would you go to? You go to your GP or your cardiologist or your whatever?
I don't know. So he asked which doctor, right? I think that your GP, if that's who you see regularly, that might be the best place to start. But if they're not willing to have that conversation with you, will the next specialist have that conversation with you? I mean, we're all terrible about going to the doctor and taking care of ourselves, especially if you're a caregiver for someone else. You're not focused on yourself. And I always tell folks when they come in, if you don't take care of yourself, you really can't take care of anybody else. And so making sure you meet with that GP regularly is a good idea for yourself. But that would be where I would start.
There's a question from one of the people watching online. Similar, but can a spouse override the living will? Not the kids, but the spouse.
No. If you put in a living will what you want, that trumps all things. If you don't have a living will in place at all, we do have a statute that tells us who can ultimately make those decisions for you, and spouse is right up there at the top. But if you've chosen what you want, they have to honor what you want.
And so how is the most form different than a living will? Because the most form also addresses the breathing machine, the tubes, the IVs, the nutrition. All those are, you check the box of what your preference is. So how is that different?
So what I tell clients, she asks what's the difference between the living will and the most order, right? Because you're checking the same boxes about life prolonging measures. What I say is the living will is something you're going to put in place with an attorney, right? Because hopefully, or you're meeting with someone who knows what they're talking about when you go through the form. But that most order, I call the living will on steroids, right? Because that's going to force you to sit down and actually have that conversation with your doctor that I wanted you to have before you signed your living will where they can be more detailed about what you really want. Now, what you want to make sure of is that all your documents complement each other. Don't have a living will that says, I want to be on machines forever, and a most order that says, I want off of everything. They don't, you don't want a conflicting document. Now, I would say if the most order was done last, it'll be honored, but make sure they work with each other, right? If you have a living will that says you want everything they can give you for as long as possible, and then you set up a DNR with your doctor, we'll go over that in a minute, do not resuscitate. Well, what are they supposed to do for you, right? You want machines forever, but you don't want them to revive you to get you on them. So it doesn't make sense.
And the most form is evaluated at least annually,
Yep.
every year, but you can change it at any time.
Yeah, so for those who don't know that, the most order you have to do annually, but you can change it at any time also. So if you're going through treatment plan and you're meeting with that doctor every 3 months, you could redo it every 3 months if you need to, but at least every year you have to address it. Nikki, was there another one?
Well, actually, I'm wondering, what is the official process? If you make a change, you go back to your attorney and they file the changes, or if you change your living will or get rid of it?
Yeah, so if you have an estate planning attorney, just go back to them, right? If you've been diagnosed with something since the time you worked with your attorney and you've set up this most order with your doctor, it would be a good idea to reach back out to your attorney and say, I've done this with my doctor, here's my situation, do you recommend any changes be made? And I do get that often where clients will send something to me that they've done and they want to make sure that it doesn't conflict with what they've done in my office. And realistically, once folks meet with me to do their estate planning, I usually don't hear from them again until something big happens. I tell them to look at everything every 3 to 5 years, but I can't make them. And so usually it's a big life-changing event that all of a sudden they're like, oh, we should probably call Jennifer and let her know what's going on. But I would recommend keeping in touch with your estate planning attorney every few years just to let them know if something big has changed to make sure you don't need to adjust your documents. Any other questions? No? Okay. So here are the forms that we've been talking about. So the bright yellow one is the DNR, the Do Not Resuscitate form. And the doctor's office gets this from the Department of Health and Human Services. You have to do it with the physician or nurse practitioner. You cannot do this with a lawyer, and you cannot print this off and do it yourself. If you try and print, you can print a copy, but it has stamped all over it that it's a sample, right? Because they don't want you doing this on your own. They want you to actually get medical advice before you enter something. DNRs often get asked, like, what age should we get a DNR? And I can't answer that question because I don't think age is the only factor. And so again, it's having those conversations when you have your annual checkup to say, is this something that we should be talking about? And then we've got the most order there, which is that beautiful pink piece of paper. Again, looking at it annually with your doctor, you can pull copies. It's really tiny on the slide, I know, but you can pull the samples from the Department of Health and Human Services website. And again, talking to your doctors about them when you feel you want to learn about them. It may mean that your conversation with the doctor is you're not doing them yet, but at least you can be educated and they know that you've brought it up, and the next year you may bring it up until you do something. Any questions about these forms?
I have a question about the most form also has DNR on it.
Mm-hmm.
So do you need both forms, or just does the most give more information?
So I like both only because I think from my older clients, they're going to have that DNR like promptly displayed at places in their house, right? They're probably not going to have the most order displayed. I think that the stop sign on the DNR catches people's attention a lot faster. But if you're already in the hospital and you have this most order in the file, they will have reviewed it and they also know what that says. Again, you just don't want them to contradict, right? Don't have a DNR and then not mark it on the most form.
An original is not, and a copy is not as
No.
good as the original.
No, yeah, yes. So copies of these documents are not as good as the original. So when you do them with the doctor, they should do multiple originals for whatever file they're going in, right? The DNR, you need an original. So they should have one in your doctor's file. If you're going to have one at home, put it there. Yeah.
Should they be notarized?
Well, you do them with the doctor. So they're gonna take care of this form and sign them all the appropriate way. All right, so you don't do it on your own. You don't have to take anybody with you to the doctor's office unless you want someone with you to have those conversations with the doctor.
How about if you're admitted to a skilled facility? Because I know that, coming in for a skill, they'll go over to the social worker,
Mhm.
pulls up that form.
Oh, yeah?
So if they don't have a MOS form in place, I know that they'll address that, or even in an assisted living facility at admission.
Mhm.
So what I'm hearing is that a physician should be the only one truly going over that document.
Well, so what the comment was that she's found that in assisted living and skilled nursing facilities, when people are going through the admissions process, the social worker is probably going to bring up these documents and go through them. The social worker is not going to be able to complete them with the individual. I think the whole point of them going over them is to say, hey, do you have this? And if not, do you want to go over it with a doctor? Most facilities either have a doctor there or they have a doctor who comes into the facility. Some facilities want you to use their doctor, others you can use your own doctor. But the whole point, there are acts that have been put in place that when you go to a hospital or a doctor's office or get admitted to a facility, they are supposed to ask you specific questions about documents. It doesn't mean that they can't force you to have them, right? You do not have to have these. They cannot make you have them. It's for admission into a facility or for doctor care. But they are supposed to ask you about different forms. So, that's just their way of doing that when they go through the admissions process. Just like most of the time now, they're going to ask about all your powers of attorney. They're going to want to know what assets you have. Are you potentially going to go on Medicaid? What bills are you paying? What are your things worth, right? Because these facilities, if they are a for-profit facility, it is a business, and they need to make a smart business decision when they let someone in their facility, right? So they ask a lot of those questions.
Well, they have to, you're either a full code or you're DNR,
Yeah.
because they have to know before you get to that moment.
Yeah.
They have to know what they're doing.
Yeah.
And what the comment for those that are on the recording is they need to know what they're doing, right? If you're in the facility and something happens, it's not like your agent's sitting there next to you all the time. They need to know what's going on and what their role is. And you should be having care plan meetings and all of those things to make sure everybody's on the same page.
What about carrying those forms with you? I mean, literally in a wallet or a purse.
So these, you have to have originals for them to be honored. So, you could fold it up and put it in your wallet or purse if you want to. I think what I tell folks is I don't know if anyone's going to be looking for them in an emergency, right? If you get in a car accident and your purse goes flying off in the ditch and all your documents are in there, they're probably not going to go look for that stuff to know that there's a DNR in place, right? They're going to do their job, which is try and take care of you. It's not a bad idea if you're traveling to have these documents with you, but I would want your agents really to have them, right? If something happens, if you have an agent who's making a lot of decisions for you, if you're caring for someone, having those originals on hand, so if there's an emergency, you can get there with them and enforce them. Was there a question back there?
Yeah. What about a DNR tattoo? Asking for a friend. No, that's a real thing.
A DNR tattoo, I am not aware of a North Carolina law that's going to allow that yet. Good idea.
No, it's a real thing.
Yeah. Not in North Carolina.
Sure, there it is.
Yeah. I have actually heard about that. Yeah. Any other questions? We haven't even gotten to the fun part about what happens when you pass away. This is. Listen, I'll tell you, every time I have an estate planning meeting, I kind of zoom through what happens when someone dies. Because my focus in a meeting when I'm thinking about elder law is the person in the room at that moment and taking care of them during their lifetimes. Now, their wishes about what happens when they pass away, that's very important. But I'm hoping we don't get there anytime soon. And that's why I always start with the powers of attorney first, because those are the most important, right? I hope that for the most part, everyone bounces their last check at their last breath, right? Enjoy your assets. Don't worry about the people after you. But having your powers of attorney, that is what's going to help someone care for you and make sure your wishes are followed. And that you're not put in a position where, again, we're going through guardianship and we're spending a lot of money and we're fighting in court to have someone to do these things for you. So any other questions before I jump to, you have now passed away? No? Okay. All right. Last will and testament. Most people know what this is. It's giving you the opportunity to choose who will get your stuff when you pass away. You choose your beneficiaries. Here's one note you need to know. You cannot disinherit a spouse in North Carolina without a prenup or a postnup put in place, okay? So postnup and prenup, they're not just for divorces anymore, okay? It is about estate planning too. I mean, blended families are a big thing, right? When you have couples come together and they have their own respective children, right? I can't tell you the number of times they come in, they love each other so much, and they've just always agreed that their stuff goes to their kids. Well, that's great, except if one of your kids is evil and they have your power of attorney and they're going to blow it up by using this I have a fiduciary duty to get my mom everything she's legally entitled to argument. So if you have a blended family and you know you want to keep things separate and you've already established that, just do a prenup or a postnup, right? Just get it in place. And then that way no one can undo the plan that you have. Because otherwise, we have this whole elective share statute that says if you are married for X number of years, you get this % of your spouse's estate, period. Right? And so they have to challenge for it, but they're going to win if they could prove they were married to you. So make sure that you know that. You can disinherit children. And I love doing that. When people come in and they say, my kid has not talked to me in 4 years, but I feel like it's the fair thing to do to give them something. No, it's not. It's not. You have no obligation to give someone something. If they don't have a relationship with you, you'll be dead. Who cares, right? They'll be mad, but it's okay. You don't have to leave them something. If you are the sole caregiver for your parent and they're like, I'm just going to give you everything because your brother has done nothing for me, they are allowed to do that. You should not be the one to call the lawyer and tell them that's what your parent wants, right? You should just get them to the lawyer's office and walk away and let them have those conversations with the lawyer about disinheriting your sibling. But they can do it. And if you work with an attorney who has dealt with challenges to these documents before, they're going to put a lot of stuff in these documents to not make it worthwhile to challenge later, right? I will sit down for an hour and write down every bad thing my client says about one of their kids. Because I know that if the document gets challenged in the future, my file is going to be in the evidence. And they're going to see all the stuff I wrote down about how bad this kid was. And so, it's important. You can facilitate the meeting, but don't be the one to tell the lawyer what the parent wants. Let them say that out loud. A last will and testament means probate. So most people don't understand the distinction between probate and non-probate assets. Non-probate assets are assets that you own jointly with right of survivorship with someone else, or you've named a beneficiary. And the reason why we call them non-probate is we don't need a court process to get that asset to the beneficiary or joint owner, because by contract with that institution or on that deed, it's going to happen automatically. So when a client comes in and one of the first things I like to do is write down a list of every asset they have, how they're titled, and if there are beneficiaries listed. So that I know, well, if I just do a simple will for you, which there's really no such thing, but if I do a simple will for you that says everything to your sister, but I found out that every financial account you have, you've named your brother as beneficiary, I need to be able to inform you that those accounts are not going to go to your sister through your will, right? But the great thing about probate, believe it or not, is the court supervision can be great about making sure that everybody gets what they're supposed to get, and there's no fighting saying someone's not doing their job, because at the end of the day, the court's going to make sure that the job is done. And they will make sure it's done. They will harass the attorney or the executor with all kinds of notices saying you are missing deadlines and we're going to send the sheriff to your office or to your house if you don't get things filed. So probate can be a good thing. The other thing to keep in mind in North Carolina, probate is not the end of the world. There are other states, Florida, New York, that probate is a nightmare, right? And it takes 2 and 3 years to get things done and nobody wants to deal with it. But in North Carolina, it's really not that bad if you've planned well. If you have beneficiaries on everything you can and they're just dealing with a house, for example, it really doesn't have to be that terrible. And then naming that person who's going to be executor to take care of it, right? Again, that takes the fighting out of it. If you name your son and he's the executor unless the court determines that he cannot serve and cannot qualify, right? So again, you can alleviate some of that fighting about being very clear what your wishes are, but it will not be helpful if you have a will that says everything to Johnny, but all of your bank accounts name Maria as the beneficiary, because Johnny's going to be like, what's going on? And he's going to blame Maria and he's going to say that she conned you into signing these beneficiary agreements, and that's going to be a lot of fighting. So when we talk about making sure everything works together, I mean, this is part of it. So you should be thinking about probate and non-probate assets at the same time, okay? There are specific execution requirements for a will in North Carolina, not to bore you with too much, but if it is a typed up will, to be an attested will, you just need 2 witnesses. But what that means is when you pass away, we have to find those witnesses, which if you've done a will in the 1970s and I'm trying to probate it this year, I'm not going to find those witnesses, right? So we like to have what's called self-proving wills, which means that the testator, the person who's doing the will, and the witnesses, all of their signatures are notarized. And there's specific verbiage that needs to be there to make it self-proving, but it's just a better way to handle it. And if you can do it that way, again, you're not having a will out there that says everything to Johnny, and now Johnny can't probate it because the 2 witnesses you had died, right? Because then we can't do anything with it. Holographic wills are handwritten wills. So in North Carolina, we can honor handwritten wills. And so you can write on a cocktail napkin, this is my last will and testament. I want everything to go to these people, right? And this is who's going to be in charge of it. And that can be honored. Now, there could be a lot of issues with that. And that's where lawyers can get paid some big bucks. So there's a lot of fighting and we get handwriting experts and things like that. But you can do it. And I mean, I know of a certain lawyer that I'm not going to say names, that every time before she would go on a trip, because she failed to type up her own will that she knew how to do, she would handwrite a will about what she wanted and leave it with her important documents, because at least I had something. I mean, she had something. So, will challenges. It is in North Carolina, they're called caveats. And it essentially someone's coming forward and they're saying, I know that the court accepted this will to probate, meaning the court said, this is the last will and testament of this person who died, but I don't think that was their last will. And there's really only 2 ways to challenge it. You either have to claim the person lacked capacity to sign it to begin with, or that they were unduly influenced to sign it. And but for that undue influence, they wouldn't have signed it. And that is where a lawyer can be really helpful, because if you have an estate planning attorney who maps out why you're doing what you're doing, and they meet with you alone and they don't let anyone else in the room. And if you've been diagnosed with dementia and they're kind of on the fence and they get your doctor to provide something in writing that they believe you have capacity, right? We are already building a file of evidence that if your will is challenged in the future, we can overcome that. So as an estate planning attorney, I'm the first person that gets called if there's a will challenge, because I'm going to have to testify or provide a deposition. Right. And I want to go in there confidently and be able to say, oh, I remember this case. Let me read my notes to you. Right. And so, again, challenges are out there and we've been on both sides of them. There's some really bad people out there that will influence someone to sign a document. And again, there are some not great lawyers out there that will meet with someone for half an hour, draft the document, have them sign it, and they're done. Right. And they don't ask any of the tough questions that an elder law attorney might ask or a seasoned estate planning attorney would ask. 10 minutes. Oh my gosh. Okay. Revocable trusts. So I forgot I had another funny thing. All right. This is me and one of my kids, right? It says, then the dragon ate the prince, but his trust lived happily ever after. It's kind of lame, maybe. Anyways, so revocable trust planning is a way to do all kinds of things, avoid probate, and control things from beyond the grave, right? So if you have a beneficiary that you do not want to inherit directly because they will blow it, right? Maybe they're financially irresponsible, or they have a substance abuse problem. Maybe they have special needs in their own public benefits, right? You can set things up in a way where you don't have to disinherit them, but you can control how they get their inheritance. If they're under 18, they can't get their inheritance, right? They got to have guardian appointed for them to manage their money until they're an adult. And I don't know how many people want an 18-year-old to actually inherit anything anyways, right? Trust planning could be a really great tool to be very specific about how you want someone to receive something. So you can give a whole lot of guidance to the trustee. You can pick corporate trustees to serve or individuals. You can pin children against each other by putting one child in charge of their brother or sister's inheritance, and those are fun. But the whole point is that you can control a bit more than under a will, where most of the time a will just says everything goes outright to these beneficiaries after my debts are paid. Revocable trust can actually also be beneficial for you during your lifetime. So if you fund a revocable trust, maybe you don't have, one of the biggest questions I get asked by someone who has no one else in their lives, They don't have children. They're not close to nieces or nephews. Their siblings have died, but they need someone to help manage their financial affairs for them if they can't do it themselves. Setting up a revocable trust that owns their assets and then naming a corporate trustee to serve might be a really great way to resolve that issue, right? So you could pick a corporate trustee in town who's going to be bonded, insured, and all of those things. You make a relationship with them. And then if you do end up in a facility or you need bills paid, they'll step right on in and do the job. And they'll have a lot of direction on what to do within the document. And then we have an entire uniform trust code that is so much fun to read. And that also gives them direction. That wasn't a joke. I really, it is fun to read. Amy, back me up. Okay. You can't. Now I'm a nerd. I got it. So revocable trust, the cons to those, it does cost more money to set them up. It is a completely separate document. And so that's going to cost money. It may not be cost efficient for everyone to do them. I am not a pusher of everybody needs a trust because it's just not true. But it does provide some privacy. It's not going to be filed with the courthouse, right? No one can, not that anyone really does this, but they can't go to the courthouse and pull a file to see what your trust says like they can with your will. And so it gives you a lot of flexibility. This one I do a lot, special needs or supplemental needs trusts. This gives you the ability to provide an inheritance to someone who's on public benefits, but it won't knock them off their benefits. So the old school way of planning for a child with disabilities was to leave them nothing and give everything to their typically developing sibling or someone else and trust them to do the right thing. And it didn't happen, right? In some cases it did, but it's not a very popular thing, right? You inherit a whole bunch of money and then you turn around and spend it on somebody else. But this is the way to get around that. And again, corporate trustees are an option, individuals are an option. There's so much guidance through the Social Security POMS, which is all the regulations through Social Security for SSI benefits. There are rules through Medicaid. And so if someone is on benefits and they're in a group home, right, and you don't want them to lose their benefits, but you'd love for them to have extra money to go to Disney every year or go to a Duke basketball game, right? Or maybe I'm from Alabama. I didn't know which one to choose. So, it gives them money to do something else. And then the great thing with these types of trusts is that you can stipulate that when that person passes away, where you want the rest of the money to go. So it might be a charitable organization that you really care for. Maybe you have other children that would receive it, but you get all the control to decide where it goes.
Can I ask a question?
Yes, ma'am.
That's my situation. How much money can they pull out of that trust? Is it a set amount that they're able to have?
So there are different types of special needs trusts. So the question was how much money could be pulled out. So there are different types of special needs trusts. The big overarching thing is you don't really want to give money directly to the beneficiary, because if you don't do that the right way, they could lose their benefits because it's seen as income. But you can pay vendors directly. You can set up a TrueLink debit card for younger beneficiaries so they have a debit card with some money on it. But there's not really a limitation on how much can be used from the trust every month.
Oh, okay.
So it's the trustee that you need to pick carefully. So you need a trustee for a special needs trust who will actually pay attention to the rules and not make a $5,000 distribution to the beneficiary for 3 months in a row. And now all of a sudden SSI, Social Security knows about it and they're going to lose their SSI benefits. So again, when you do this type of planning, meeting with an elder law special needs attorney who's going to walk through all of that, and we are going to painstakingly talk about who that trustee will be and why they should serve or shouldn't serve. Right. And there are very few corporate trustees out there who will serve on special needs trusts because you have to pay that much attention to detail, but they're out there. Hey, how am I doing? Good? Because this is my last slide. That's just me. Do we have any other final questions? I know listen, when I meet with new clients, I try and go through, the whole estate planning meeting in an hour, but we are very rarely talking about revocable trust and special needs trust and all those things at the same time. And we're very rarely going into detail about guardianship. It's not an easy thing to grasp in an hour. If it was, I wouldn't have a job. And so, if you have questions, I don't come and speak at things like this because I'm trying to garner business. I think that we only work together well as a community if we help each other. And I'm here, my business cards are over there. if you have a question that pops up and you just don't know where else to turn to get an answer, please email me. I promise I won't send you an invoice. I want you to feel like you have resources out there. And I will tell you that there have been many times I've had someone call and all they want me to do is review documents they had done by another lawyer. And usually they're done just fine, right? They don't need any changes. And hopefully I can encourage you to be like, keep working with your lawyer. They did a great job. I'll be honest with you if they didn't, right? But again, it's just about making sure that you get the support you need in the community. So please know, elder law attorneys in general will support you, all of us, right? It's not just me. We have other elder law attorneys in town that if you call with a question or get on the phone with a paralegal, they'll give you resources. They'll get you to somebody because we believe so much of what we do. It's not about, a cash cow for us. It's more about who we're working with. Did you have something, Nikki?
Yeah, you might have answered this, but if a state documents were originated in another state, then are they honored here or do they need to be changed to North Carolina?
Okay, so the question was, if you have documents done in another state, are they honored here or do you have to redo them? So the quick answer is they will absolutely be honored here. The long answer is if they weren't signed in accordance with North Carolina law, there may be some red tape to get them honored. So if you move here, and you have capacity to sign new documents, meet with a lawyer and have them review them to tell you, these don't actually match with what we do in North Carolina. You might want to redo them. But if you've moved a loved one here and they had documents done in New York and now they're here and you're caring for them, those documents can absolutely be honored here. And if you're told that they can't, the person doesn't know what they're talking about. And so I do opinion letters all the time that say this document was done in accordance with New York law with this law firm, right? They're in this statute in North Carolina says it's valid. Okay.
Ask about costs.
Oh, yeah.
What do fees start at for this process?
So I have two people on opposite sides of the room talk about fees. So here's the big picture. Every attorney does it differently, right? Some attorneys, like my office, we do a lot of flat rates for estate planning because there's an art to it. We figured it out. We're not going to charge you an hourly rate because honestly, at some point, that's not cost efficient for us. Some attorneys will do an hourly thing. What I would say is we're all kind of used to people calling around and shopping around. That is our market, right? And so if you call my office or another law firm and you say, well, what are your typical fees? Most of the time, they're going to tell you. Some attorneys do consultations at no charge for estate planning because their hope is that they build a rapport with you and you stay with them. Other attorneys may charge an hourly rate to sit down with you and map out what the plan would look like. And at the end of that meeting, they could tell you what it costs. There is no shame in shopping around if you're trying to look at what's the most cost-effective thing. And I will tell you that with cross referrals with elder law attorneys, I've had people come in that I know they couldn't afford to pay my fees. I'll hook them up with legal aid. Now, you should have called legal aid. Let's go through them. Most elder law attorneys do pro bono hours through legal aid. So people who can't afford a lawyer, we get them anyways. We just do it pro bono and we make sure that legal aid gets the credit, right? So they can keep getting the money that they need. There are other attorneys in the area who may charge a little less or a little more, but we kind of get those people in the right place. Cost shouldn't be a barrier to estate planning, period. And so if you need to get it done and you can't afford to get powers of attorney done because you really don't have the money, we have the resources in North Carolina to get you those services. So again, you need healthcare documents or living will. Hospice has wonderful forms. We have free statutory forms. They're not perfect, but they're there. And again, we have legal aid. And legal aid will funnel those cases out and get you to an attorney who does this kind of planning, and then you won't be paying for it, right?
There's a question online, which is, does your firm help with elder fraud where a caregiver took advantage of an elder person?
Yes, we do. That's called fiduciary litigation. Not every elder law firm will do fiduciary litigation. It's definitely a civil litigation area, and not all of us have the resources to do those kind of lawsuits. But we do. And there are a couple other firms in town that if we can't take the case on, we might refer them out. And the great thing about a lot of fiduciary litigation is what they say in law school is 90% of cases settle outside of court. And I think that's still pretty accurate. If you scare somebody enough, they'll eventually write a check or enter into a promissory note or give the deed back. But the important thing is to act quickly, because when someone abuses a power of attorney, they're not typically taking that money and saving it. they're blowing it, right? And so if they blow it and they don't own anything for you to recoup from, then it may not even be worth doing a lawsuit because you'll spend more money than you'll get. But there are also things you need to look out for. Adult Protective Services, right? If you think that someone's being exploited or abused, you should report that to APS. Let them do an investigation. If they find merit that someone is actually, if they substantiate that exploitation, they can report it to the police. They can have charges brought. The DA can bring cases. So don't hesitate to report those things. Yeah. I know I went over.
You're fine.
It's fine.
Great.
Sorry. I'll stick around for a little while. Thank you so much for having me for your first meeting.
First of all, a huge thank you to Jennifer Roden. You can see why we picked her for our first presenter. She does an excellent job. If you didn't get all of the information and you wanted to refer back to it, you can go to the ACAP website and the videos will be up there, as well as presentations from other programs. So there's other ACAP programs, other locations in North Carolina, Pennsylvania. There's one in Atlanta. I don't think it's going quite yet. But you'll also have access to any of those presentations as well. So also wanted to just kind of go through a few things. This has the ACAP email and website on the back. So if you didn't pick up one of these, they are, I think, out on the table, or you may have been handed that. The other thing we would really love is for you to fill out this ACAP program feedback form that's at your table. This helps us know how we can make these programs better. And I do thank you for your patience. We had a little bit of a late start today, so thank you for that. A few technical sounds in the background that we'll work on. But if you could fill that out, that just lets us know what we can do better, how the program was for you, and you can leave it at your table and flip it over, and we'll pick that up also. There's also a form that you should have received. If you did not, make sure you get that. It says ACAP Cape Fear at the top, and it has the 6 programs that are coming up. So today was all about the law and the different forms. Next month, it's going to be on insurance, specifically Medicare and CHIP, and we have 2 experts in those areas to help you understand prescription drug assistance, what are the different Medicare options that you have and how to select those. And then you can see all the programs scheduled out till February. And again, it'll always be the second Tuesday of the month from 6 to 7:30 right here. So same time, same place. And if you know other people that might be interested, feel free to grab some extra brochures or flyers to share with them. And let's see what else I'm missing. Thank you to our sponsor, to Lower Cape Fear. They have information on that table by the window, and then our other core sponsors are back there. So if there's anything that you're already kind of thinking about that you might need, you can look back there for those as well. And I think that's it. So thank you all for coming and being part of our first program. Thank you for those online that are watching us, and huge thanks to Jennifer.
I don't know, Saturday stressed me out a little bit. I was a little bit.